Hey everybody, good morning. Okay. So James Crumbley will be in court today asking for a new trial. It looks like they're setting up. Good morning, good morning. Hold on, I'm just still getting things set up here. They should be starting in about 7 minutes. And Mr. James Crumbley is asking for a new trial. Hey, Bunny. Hey, Lid. Bunny, Lid. Good morning, Rain King and Chris, Evelyn, Kristen, Mr. Cole. Old morning, good morning, old morning, whatever, Chris. Whatever works.
I can hear you, but I can't hear you, Chris.
So you won't be doing Chris.
Oh, okay.
She's basically playing the part of if somebody's joining in.
Oh, okay.
Hello, Margaret from Scotland. Good morning, Dreams. Good morning, peeps. So I was reading on Facebook. I don't know if James is going to be there or not because he was still showing as in prison, which is 2.5 hours away from Oakland County Court. So there was kind of some talk on Facebook that maybe he didn't get transferred for this hearing, but I don't see why not, unless he's going to be on Zoom. Good morning, Samantha Mustard McDowell from Belfast, Northern Ireland. Very cool. Good morning, Angie B. One-Odd Lobo. Trisha G. 369, the goose is fine. Or whatever that song is. Good morning, everybody. I wasn't sure, if I was going to stream this, but I saw it. I was up, so here we are. See, look at, they're pulling up Zoom right there. I think so, Chris, because look. They're pulling up the Zoom screen now. Oh, Trisha, you did cover their trial? So Jennifer actually filed a motion to get Karen McDonald off the case, and that was denied. Come on in, the coffee is hot and the host is amazing. Oh my God. You didn't cover the son. You didn't cover Ethan. Good morning, Queen Bee. Good to see you. Good morning, Cooters.
Y'all welcome to Cooterville. Come on in and remember, close your legs.
Freaking Chris.
I might have to call it
Just not connecting, not recognizing.
Good morning, Miss Cals. Welcome in, welcome in. I wonder why he's asking for a new trial. Well, my guess is that he's going to claim something wasn't fair. Something wasn't fair.
Yeah, God willing. I mean, not God willing. I don't need any business. I confirm.
Good morning, Cutsy, 1977. I'm here for you. I've got you.
Yeah.
How long did the parents get? Didn't they get like 14 years or something? I don't remember offhand. Hey, Big T. I'm probably going to get slammed for not knowing, but I guess according to my comments yesterday, I'm supposed to remember everything. I had like the worst comment when we ended Lori Vallow's trial yesterday. Some person comments, "You shouldn't be covering true crime because you don't even know the case of Lori Vallow. Maybe you should do your research first." And I'm like, what? 13, or that's what I thought. It was around there. 15. Yeah, this person's like, "You don't even know the Vallow case. I don't know why you're covering it." Hey, Regina. Yeah, I mean, I can't remember every single detail, but I try. You know what I mean? That's why I go back to my old videos. See, they do have Zoom up there. He's probably going to put his ass on Zoom. Thank you, One-Eyed Flo. Melissa B., good morning, hon. It is hard to remember every detail, especially years later when you're covering other cases too, right? Some people are just never happy. It's just the way of the world. But look they're all seated and ready to go. No James. That Linda Sturmer retrial case. Oh, is it already in deliberations? That one in Michigan, too? Evelyn, people are just ridiculous. But it's just so rude. It's like... I need more coffee. Jay, are you originally from Michigan? I am. From the Romeo, from Romeo. Thanks for keeping us updated on this case while everyone else is hyper-focused on Lori. You're welcome, Callie. I like to follow up on cases, like, if anything goes on after we cover them, for sure. It's always interesting to see. Do I think he'll get a new trial? No. Do I think that he's got a reason for a new trial? Probably not, but they all ask, don't they? I mean, hell, I'd ask too. Sister Bear. You lived in Shelby. Oh, wow. Nice. And you're in the UP now. Pontiac here. What the hell is going on in Oakland County? Stacy? I don't know. I live about 19 miles from Oxford. The mother went to Clarkston High School, was a real estate agent. There's something not right here.
Oh, okay, good.
The mom asked for a new trial. Yeah, I don't think that's been ruled on yet, though.
But for a little bit, we were calling you all.
Near Flint. Trisha talks. Switched accounts.
We're trying to find another mic.
Thanks for being a member, Trish.
The microphone working for the podcast.
Why do they always look at the technology like it's never been used? I know. You would think they would know how to run a Zoom after the pandemic and stuff.
Stream at that point. You'd be able to watch it like anyone else in the public.
Sure.
Through the webinar. Like that's.
Here.
Yeah, we would need the microphone to have any interaction.
Shelby's really close. It's a small world, Evelyn. You don't like Karen Dragonfly? So the lawyer's probably going to talk, and James is probably just going to sit there on Zoom. I lived in Pinckney until I was 11 and then moved to Alabama. Cool. Good morning, Heather. Is the judge going to be Judge Matthews? You know what? I'm going to go quickly make a cup of coffee. Very, very quickly. I'll be right back. And thank you, Flo, for that.
Check 1 2. Yeah. All right. So it's probably something with the wiring or connection up there. So if you want to exit the meeting, go into the webinar. Yeah. Yep. Yeah. Correct. That's cool. Once you promote them, it will start feedbacks between the polygon and the camera that's broadcasting the webinar. Yeah. Yep. Your audio. But I'm going to double check the mic. Yeah. Clean the breath. So then, yeah, we'll just need to join the webinar ID. If you need that, it's like a green checkbox.
Thank you.
I'm back. Welcome in, everybody. Hey, Melmo. Melmoj. Hey, Yoga. Do you love it, Yoga? Jay, did you follow the Daryl Brooks? No, I didn't. Not religiously. I mean, I watched some of it. Enough to have this soundbite.
Did I ask them to do that?
Cooterville Fafo. The judge granted a new trial in what? Daryl Brooks? I think he fired his attorney in his appeal. Fem, you want Shannon back? Is it going to be Judge Matthews, though? Does anybody know? You can't remember what trial? Well, we've covered a lot of trials.
I'm gonna get drunk and ride my horse.
Thank you for your support.
Kelsey Virgo, thank you for thank you for the pizzas and coffee. Taylor Swift for the opening. Oh my God, I forgot about that. He's going pro se for his appeal, yeah. Chris, hey Trouble Mint. You're welcome, Evelyn.
Bring it all in.
Karen was a judge. Really, Dragonfly? I didn't know Karen was a judge and stepped down. Listen to the talk. They're cozy, aren't they? It was supposed to start at 9, but... Oh, you're kidding, Evelyn. Oh, here we go.
Oh, yeah. Thank you so much.
What are they doing?
We're ready to get started. Yes.
Who's ready?
I can't with this view.
Thanks, Ashley.
Oh my God. This is going to be a trip. It's going to switch that fast. Why is the camera switching so fast? Good morning, Chris. Good morning. Oh my God, this is going to make me dizzy. Jesus. They never did this before, y'all. What is this? Hey, Mari. Welcome in. Angie B. I know, Cole. I am too. They cannot do this throughout the whole thing. They can't do this to us. You think it'll slow down when they start talking? God, I hope so. Hey, Sarah Smith. Good to see you. Feel like it's been a minute. Okay, it slowed down, guys. Oh, I spoke too soon. Prior to her election as Oakland County prosecutor, Karen was a judge on the Oakland County Circuit Court. She was elected to the bench in 2012 and re-elected in 2018. Why didn't she want to be a judge anymore? Heather, I know, I feel you, girl. It is too early for that. Dingbat's getting motion sickness. Hold on, guys. I got a call coming in.
All rise. Court is now in session. The Honorable Shirley Matthews presiding.
Good morning. You may be seated.
Here we
Sorry to
go.
make you wait. We're having technical difficulties.
Your Honor, calling People v. James Crumbley, case number 22-279-9989-FH.
Good morning.
Good morning, Mark Keith on behalf of the people.
Good morning, Joseph Shada on behalf of the people.
Good morning, Your Honor. Lorna Sharon on behalf of James Crumbley. Your Honor, can Mr. Keese and I approach very briefly?
Well, the problem with that is I have about 5 microphones here, so anything you say to me will be on channels 2, 4,
That's
and 7.
fine. Mr. Keese and I plan on putting it on the record. I just wanted to inform you of something.
Is it loud enough, you guys?
Okay. Okay.
Can you approach?
You can approach, but I can't.
Yeah, they're going to hear you.
Sure.
If you approach, they're going to hear you, she said.
Oh, yeah, would you be able to cut the mics for me?
Oh, my God. Cut the mics? We're 20 minutes late. We're 20 minutes late. And now we're cutting the mics. What's going on here? The sound is good? Okay. I just wanted to make sure it was loud enough. A boost a little bit. So this isn't an appeal. James is asking for a new trial, but we don't know the grounds. We don't know what he's basing the new trial on. And thank you, One Eyed Flo, for sharing my playlist. Oh my God.
Just based on my observations, her hair was very greasy.
All right. Today is the date and time set for defendant James Crumbley's motion for a judgment of acquittal or in the alternative a new trial. As has been this court's practice in each hearing over the past 3.5 years, the proceeding is being conducted in person. In keeping with that procedure, we alerted all parties that defendant James Crumbley would be writted from the Michigan Department of Corrections. Ms. Sharon then indicated to my chambers that the defendant did not wish to be brought here for these proceedings.
He didn't want to come.
Right. Ms. Sharon also requested that her client be permitted to participate by Zoom. The court indicated that there would be that we would make that request to the Michigan Department of Corrections. We also obviously have more ability to control that at the Oakland County Jail. But we were unsure about whether the Michigan Department of Corrections would accommodate a Zoom hearing with the defendant that can potentially be lengthy. The Michigan Department of Corrections has accommodated that request to the extent that Mr. Crumbley will be able to see and hear these proceedings. And Ms. Sharon, I think you've indicated that Mr. Crumbley, although he has the right to be present for this hearing in the courtroom, that he's willing to waive that right to be present in court.
Absolutely, Your Honor. As the court has correctly indicated, it was our request that he appear via Zoom, so I would waive his appearance for purposes of this hearing. All
right, thank you. I wanted to indicate before we got started that I'm not in the habit of issuing late opinions. I tend to keep up with my responsibilities, so I wanted to let you know that I thought it would be appropriate to not issue an opinion on the remaining issue in the Jennifer Crumbley matter until hearing oral argument in this matter. So I will get back to you as soon as possible with regard to that.
Thank you, Judge.
All right. So I'm going to ask you to all please be mindful that I've read and thoroughly reviewed the motion filed by the defendant, the response filed by the Oakland County prosecutor, and the reply filed by the defendant. In fact, I read the entire guidepost report as well. I think it'd be helpful if we went issue by issue with Ms. Sharon giving her argument, the prosecutor responding, then Ms. Sharon providing any reply.
All right, we're going to hear the arguments.
Right? So, Ms. Sharon, it's your motion. You can address each issue raised in your motion in any order you see fit. All right?
Your Honor, before I begin, when I typically argue in front of the Court of Appeals, I don't always touch on every issue that I've briefed, and I did not intend to do so today.
She wants you to.
I'm so relieved.
I'm glad I could make your day, Your Honor.
Yeah.
So as long as that is acceptable to the court.
I have read everything more than once and have pulled the cases and read the cases. So I think oral argument is important. But I would appreciate hitting the highlights. You did an outstanding job on your brief, and it's very detailed. If you filed it,
you should know. You should know every point.
But it is Friday, and I don't want to be here till 10 o'clock at night. So.
I understand, Your Honor. So I will proceed as I had planned.
Okay.
But of course, if the court has questions, on any of the other issues, I'm always more than happy to answer those.
Let's go.
Again, Alona Sharon on behalf of Mr. Crumbley, Your Honor. Mr. Crumbley is entitled to a new trial for a number of reasons, the least of which is the concealed proffer agreements. And so, Your Honor, I want to start off this morning by talking about the court rule, the discovery rule that's at issue here, which is, of course, MCR 6.201B5. Your Honor, the prosecution would read the court rule so that the phrase, quote, for testimony modifies all terms of that subsection. So it would modify any plea agreement, grant of immunity, or other agreement. But the prosecution's suggested reading of the court rule does not comply with our rules of statutory interpretation, rules of grammar and punctuation, and perhaps most critically, Your Honor, it does not comply with the purpose of the court rule. First, Your Honor, the court rule is not ambiguous. The use of commas in B5 separates each clause such that the rule requires the prosecution to disclose any plea agreement, 1, 2, any grant of immunity, or 3, other agreement for testimony in connection with the case. But if Your Honor does find that the court rule is ambiguous, then it should look to the rule of the last antecedent. And under the rule of the last antecedent, Your Honor, the clause for testimony modifies other agreement and not the first two phrases, plea agreement or grant of immunity. Under the rule of the last antecedent, Your Honor, and just general rules of punctuation, a comma would have to be inserted after or other agreement to reach the prosecution's reading.
Punctuation.
So essentially what the prosecution is asking Your Honor to do is read a comma into the rule that isn't there. And we're told by our case law that we presume the drafters of these rules are familiar with rules of punctuation and grammar, Your Honor. But the most compelling reason, Your Honor, that the prosecution's reading of the court rule must fail is because it's not supported by the purpose of the rule. MCR 6.201B5 is born out of Brady versus Maryland, Your Honor, 373 U.S. 83. That case requires the prosecutor to, quote, disclose any information that would materially affect the credibility of his witness. In People versus Atkins, 397 Mich. 163, our Supreme Court stressed that the focus of requiring disclosure in such situations is to reveal factors that the jury may consider in weighing a witness's testimony and which may motivate the witness to give certain testimony.
Well, let me ask you this.
Yes.
I don't want to mess with your mojo because you're sort of on a roll
Don't
here,
worry.
but
I've got more mojo than I can handle
okay,
right now.
So what if I agree that the prosecutor violated the rules with regard to discovery? What if I agree with that?
So where does that take us next?
Yeah. So,
Sure.
So you're telling me about a Brady violation, but
No.
what is the remedy? What is the remedy if there's a violation of the rules of discovery? Just plain old 6.201B2.
Sure, Your Honor. And I will answer that question in 10 seconds.
Okay.
I do just want to point out, because I feel like when the other defendant's case was argued, there was this sort of conflating of discovery violation versus Brady violation.
They're separate.
Okay, and I believe that Your Honor understood that concept. I just didn't feel like it was super clear on the record. So right now, I'm addressing the discovery violation. So as to your question of what is the remedy, right? What is the sanction?
Because then you started telling me about Brady, so I agree with you that they're separate.
So, Your Honor, I referenced Brady because 6.201B5 is drafted in the spirit of Brady. It is drafted in the spirit of protecting a defendant's right under Brady, but they are two different claims.
Okay.
As to the sanction or the remedy, Your Honor, so we look to 6201J, right, that talks about violations. And under the court rule, as well as the applicable case law that's cited in the brief, Your Honor has wide discretion to grant an appropriate remedy or sanction. And Your Honor should be guided by a variety of considerations. First, if you just look at the plain language of 6201J, it lists several examples of remedies that Your Honor could use, except none of those would be helpful in this case because the prosecutor didn't disclose until following conviction. So then you keep reading, or enter such other order as it deems just under the circumstances.
And you're saying that would be a whole new trial?
Absolutely, Your Honor, because it is the only way to make Mr. Crumbley whole. It is the only way to correct the violation of the court rule. If someone could suggest to me some other sanction that could remedy this wrong, I'm happy to hear it, but there isn't one, right? And that's why the prosecution has to keep hounding this argument that they didn't have to disclose this immunity proffer agreement, Your Honor. Your Honor, I guess I would ask you, if you are at the point where you feel like this was a violation of the discovery rule.
I likely do.
Okay. I can take the message that Your Honor is telegraphing, Your Honor. I do want to remind the court that back on January 31st, when Jennifer Crumbley's case was being argued, Mark Keast argued to this court that his office did not have authority to grant immunity outside of statutory immunity. That's a direct quote. The only way to grant immunity is to petition the court. It now seems
You're talking about oral argument on Mrs. Crumbley's motion.
Yes, Your Honor.
Okay.
And I do cite to it, I believe in the brief.
Oh, you're talking about this year, not talking about the trial. Yeah.
Correct,
Okay.
Your Honor.
Right.
So it's remarkable, and it should be remarkable to this court, that it appears at this point in time they've abandoned that argument, Your Honor. It's nowhere in their response brief. I don't know what Mr. Keast will argue today, but they absolutely do have the authority to bestow immunity outside of statutory immunity, and that is what this argument was. So to go back, Your Honor, to the remedy, I do want to talk a little bit more about that. According to our case law, when Your Honor determines the appropriate remedy for a discovery violation, you must consider and balance the interests of the courts, the public, and the parties in light of all the circumstances, including the reasons for noncompliance. Your Honor's paramount interest is that the discovery should facilitate the search for the truth. The public's interest, Your Honor, is that when a trial concludes, it can have faith in the outcome of the trial, and obviously a party's interest is that it be able to properly prepare for trial. And the court should also consider whether the objecting party was surprised. Every single person in this courtroom, with the exception of 4 people, were surprised, Your Honor, by the existence of these proffer agreements. In People v. Taylor, 159 Mishap 468, the court instructed that the first question for Your Honor to answer when fashioning a remedy is whether the party's interest in preparing his own case or his opportunity to test the authenticity of a witness or the authenticity of evidence has been prejudiced, which it has been here, Your Honor.
Can I ask, I want to ask you about Taylor, but
Yeah.
can I ask you what kind of immunity you say that they conferred? Because it's not transactional, right? And with regard to use immunity, doesn't use immunity protect a witness against compelled testimony? There was no testimony compelled by either Ejac or Hopkins. I think your brief says pocket immunity. I don't know. So what flavor are you alleging of immunity?
I don't know, Your Honor, that there has to be a specific title to the type of immunity, but the case law is cited in the brief that references, right, pocket immunity is one of the phrases, informal immunity, but the case law is clear that where a promise is made in exchange, even just for cooperation, that is a form of immunity, Your Honor. And here, obviously, the plain language of the proffer agreement promised Hopkins and Ejac that any evidence or information that was provided to the prosecution during these proffer meetings could not be used against them in the prosecution's case in chief.
Okay.
So that is, I do agree. I guess I respectfully disagree that it's not use immunity, but even if you don't want to give it that proper title, it certainly is a form of pocket or informal immunity, which would still be required to be disclosed under Brady and under the court rule, Your Honor.
Okay. Yeah, but I don't know. I think use immunity is when the testimony is compelled. Ejac and Hopkins still don't have to testify, right?
No, they certainly were not required. I mean, they were subpoenaed. Mr. Keast indicated that at the last hearing. So obviously they were required to appear, but I think everyone agrees that they probably could have asserted the Fifth Amendment.
They probably would have.
Correct, Your Honor. The second consideration under Taylor is that what remedy may be appropriate giving due regard to the competing interests of the party, the court, and the public. And Your Honor, I want to take a moment here to address the Dickinson case that's relied on by the prosecution in its response, because the procedural facts of Dickinson are very different here. So in Dickinson, we have admittedly a discovery violation that comes to light during the trial. And instead of asking for a sanction under the court rule, the defense counsel in Dickinson simply moved for a mistrial, which is a different claim. And the review of the Court of Appeals in Dickinson is a review of a trial court's authority to grant a mistrial and whether the granting of a mistrial is appropriate. That is a different set of law. That is a different analysis. So Dickinson is really wholly inapplicable to the case that's before Your Honor today.
Well, you mentioned Taylor, but in Taylor, U.S. Supreme Court case, the Supreme Court affirmed the trial judge's exclusion of a defense witness not included in discovery, and there was some other
I was just going to get to that case.
That happened.
Yes.
Right, but that was kind of the easy button there, right? Because it was that witness was going to commit perjury. There was some underhandedness, and the witness wasn't disclosed at all, right? And the witness was going to perjure himself. In this instance, we don't have a witness that's undisclosed, right?
Correct.
Ejak and Hopkins were on the witness list from the beginning. They testified at the preliminary examination, right? So Taylor's a different scenario, isn't it?
Your Honor, and I don't use Taylor for the purpose of the facts being necessarily on point, but what the case stands for. May I address that?
Sure, go ahead.
Okay. So, and Your Honor has touched on this a little bit, but just to kind of reiterate the basic facts in Taylor, the defense counsel at the first day of trial moved to amend his witness list to include two witnesses, one of which he said was much more critical than the other, and reason that he didn't provide the name in a timely fashion and pursuant to the discovery order was because he had trouble locating him, so he didn't have an address, and that the witness had seen the entire incident from which the criminal charges stemmed.
And both of those things were lies.
Correct. Mm-hmm. That is correct, Your Honor. So the judge tells the lawyer, bring your witness in tomorrow, I'm going to make inquiry, and I'll make a decision. But what is remarkable in Taylor, Your Honor, is that you have a defendant who has a constitutional right, a due process right to present a defense, a constitutional right under the compulsory process clause to present evidence that is favorable to him. And despite those guarantees under the United States Constitution, the United States Supreme Court affirmed an incredibly severe sanction, Your Honor. Incredibly severe, okay? So what do we take away from Taylor? If the violation is intentional, okay, if there is bad faith behind the violation for the purpose of gaining a tactical advantage, a severe sanction is warranted. That's what we take away from Taylor. And Taylor said that the court can consider whether compliance with the discovery rule is onerous or relatively simple. Your Honor, Mr. Keese provided discovery to defense counsel 34 times. 34 times subsequent to the signing of these proffer agreements. On 34 separate occasions, he consciously decided to continue to conceal these proffer agreements that he was required to disclose under Brady and under the court rule. It was intentional, it was willful, and despite the fact that I frequently forget to attach things to my emails, it was an easy thing to comply with. It would have taken 5 seconds, Your Honor, but he didn't do it. So because the violation is intentional here and willful, it is deserving of the harshest sanction. But Mr. Crumbley isn't seeking the harshest sanction, Your Honor. He is seeking the one and only sanction that can right the wrong, that can make him whole, and that is a new trial, Your Honor. Anything short of that, and there is no correction to the misconduct, Your Honor. So again, the court is to consider the reason for the failure. So what does the prosecutor's office argue? One, they first argue that it's something that they didn't have to disclose. I really hope by now the court is not taken by that argument. The second reason that they initially argued was that it was never an immunity agreement because they can't bestow immunity, which, Your Honor, the case law cited in my initial brief clearly dispels that argument. The reasons put forth by the prosecutor are incredible, and they should not persuade this court to conclude that the misconduct was unintentional. Your Honor, the prosecution team consists of 83 years of legal experience. Karen McDonald, 26 years and a former judge. Mark Keast, 19 years. Dave Williams, 29 years. Joseph Shada, just under 10 years. 83 years of legal experience, Your Honor. Your Honor cannot really believe that 83 years of experience and this team did not know that they could bestow immunity on Hopkins and Ejac, that those agreements in fact bestowed immunity and that they were required to disclose them. Your Honor, I want to turn now to the prejudice issue. So if you look at Davy, which is companion, it's Davy and Obispo. So they have an evidentiary hearing in that case when do you have a question?
No, it's incredible to me and Davy that the defense attorneys had to go to the Detroit Police Department to get their discovery.
I don't know that that's so unusual, frankly.
Well, no, but I mean, completely. It seemed dark ages.
Oh, you mean that they didn't receive it via email?
Or, no, not email, just, I don't know.
Well, Your Honor,
I'm sure you called the Detroit Police Department,
What happened with the Detroit Police Department?
So to turn to the prejudice
There was no discovery there, though. No, zero. None.
That is correct.
Right.
But if you look at Davy, Your Honor.
It's prejudice, capital P, right?
I don't know what you mean by that.
Well, they weren't given any discovery.
Correct. But the court in Davy, never makes a finding that the failure to produce the discovery was outcome determinative. All it does is the trial court took testimony from trial counsel who testified that their ability to prepare was compromised, and that was enough prejudice. That is the prejudice that is required, Your Honor, under the discovery claim. And so let's talk about the prejudice in this case, Your Honor. James Crumbley was prejudiced because he was unable to effectively cross-examine the witnesses as to their bias and motive. He was unable to fully prepare his case. But perhaps what's most compelling, Your Honor, is that I reference in the reply brief the audio from Mr. Hopkins' initial interview, right?
I listened to it.
The day of the shooting. Mm-hmm. When you listen to that audio and compare it to the testimony that he provides at trial, subsequent to the Proffer agreements, there are distinct differences, Your Honor. Nothing in his interview to the police expresses frustration with the Crumbleys' unwillingness to take their son home. There is no mention that they refused to take EC home because they needed to return to work. He explicitly says, Your Honor, in that audio, the parents were absolutely on board to get him help within 48 hours. And he also tells the officer, look, these parents, they know that their son has a tremendous amount of anxiety when it comes to missing class. So much so that he tells the officer that James Crumbley told him he wanted to plan a family vacation and EC was going to have to miss class for it, and told his dad, I don't want to go on the vacation. I cannot miss school. I cannot miss class. So you go from these statements that he makes, right, within hours, of the shooting, where he does not express any frustration with the Crumbleys, any concern about James Crumbley that he is disinterested, that this meeting ends abruptly. And when you compare, Your Honor, those statements to the officer shortly after the shooting and his testimony, where he talks about the meeting ending abruptly, the parents not acting appropriately with EC, and I detail it all in the brief. I don't think I need to repeat it. But not disclosing the Proffer agreements, Your Honor, it robbed him of the inference that this gentleman's testimony shifted as a result of the Proffer agreements, Your Honor.
Okay, well, this meeting was 12 minutes long, right?
I believe it was 20, but 12. 12?
Mm-hmm.
Yes. But the officer asked him repeatedly about the meeting, about the parents. How was the child doing? Were they willing to get treatment for their son? And Mr. Hopkins expressed no concern about the parents, not one shred of concern, not one observation in that interview about their conduct during that meeting, about their attitude during that meeting. Your Honor, we know that without the proffer agreements, Hopkins and EJAC would not have testified. That is a reasonable inference given their lack of cooperation with the guidepost investigation. They had no interest in transparency, and their interest was self-preservation.
Okay, but the prosecutor would say that everybody's interest is self-preservation, right? So they were incentivized to shine themselves up before the proffer agreement, during the proffer agreement, and after the proffer agreement. No one, everybody, any reasonable person avoids being charged with a crime, right?
100%, but not every person is a witness in a criminal trial. That's what matters here, right? What gives them the bias and the motive to have that shift in the way he characterizes his interaction with James's interaction with EC, their willingness to get this child help. Here's the distinction, Your Honor.
He talks about it when he's being interviewed by Joe Bryan at the jail too, right? There's an interview with Joe Bryan at the jail.
Between
Mr. and Mrs.
and the child.
And the two defendants. And a lot of those things are stated there.
Are you talking about the exhibit that's attached?
It's Exhibit 2.
Yes, Your Honor. I reviewed that twice. Okay. There is nowhere in that interview where the Crumbleys indicated that they had to leave to go to work. That is not in there. There is nothing in there.
They do leave to go to work, right?
That's what they did.
Your Honor, the point is that the prosecution tries, but the reason that they leave, Your Honor, and they leave EC at school, in that initial interview with Hopkins, he makes clear that those parents wanted EC to stay in school, Your Honor, because they had serious concerns about the amount of anxiety he experienced from missing class. And that's confirmed by Hopkins. He talks about in great detail how much the students have struggled because of COVID, and that EC seemed to struggle a lot from not being in school. His grades had declined a bit from that, and his parents confirmed that not being in class was incredibly anxiety-inducing for him.
Wasn't he sleeping in class at some point?
I believe that is a statement that he might have made to the CFP, and a teacher might have reported it.
It's fine.
But regardless of that, I don't think it's disputed that EC reported and his parents acknowledged that not being in school was incredibly difficult for him, and that he wanted to stay in class. So you go from Mr. Hopkins telling the officer these parents were on board, they wanted to keep him in school because they knew he would be upset if they took him out of school, to this shifting narrative at trial that no, they didn't want to take him because they didn't want to be bothered and they didn't really think he needed help, and so on and so forth. That is a remarkable shift in the characterization and the narrative of the Crumbleys, specifically James Crumbley and his conduct in that meeting, Your Honor.
Okay, but regardless, that doesn't change. Whatever EJAC and Hopkins say doesn't change the facts. It doesn't change what happened. The parents came there. There's texts, there's videos, there's all kinds of things that happened before and after.
Your Honor, I don't dispute for one moment. They came there.
She didn't want to come at first, Mrs., right? And said she couldn't miss work, and then she comes, and they're there 12 minutes, they leave without him. Like, nothing EJAC and Hopkins say changes that.
Your Honor, the facts might not change, but the way that they're characterized and the narrative that's given around the facts, right? That's what's important, and that's what the prosecution used Hopkins for, in part, was to give testimony about how they conducted themselves in that meeting. The fact that they seemed almost irritated about having to be there. The fact that the meeting, quote, ended abruptly. And then this assertion that they really didn't seem to think getting help for him was important, which is the total opposite of what he says in that meeting immediately after the shooting. His exact phrase was, they were on board. That's it. So how do we go from there to portraying these parents as not caring, not knowing their son? It's just, they don't coincide, Your Honor. They are distinctly different.
Well, she wasn't going to come at first, right? She said call the dad.
Your Honor, she's not my client.
Oh, I know she's not your client.
Mr. Crumbley
But you
is.
said the parents, so... You know.
I apologize.
Yeah.
But when you look at globally his statements, to be fair, I mean, he talks mostly generally, right, about mom and dad. You know, he tells him, no, they came to the school, we had this meeting. He even talks about them telling him about the grandmother passing away, about the loss of the dog, about the friend moving away, so on and so forth. So there is this exchange of information, and there's never a characterization at that time that they're somehow inappropriate.
Well, they're going to say there wasn't an exchange of information.
Well, I understand that that's what they say, except that Mr. Hopkins' interview says otherwise.
No, the prosecution's going to say there wasn't an exchange of information. If there was an exchange of information, the prosecution's going to say this wouldn't have happened if there was an exchange of information.
Your Honor, at that moment in time, Jack Hopkins, James Crumbley had no reason to believe, and this kind of dovetails into the legal duty argument, that EC was had a propensity for violent acts. Okay, under the law, and I yes.
What about that picture?
Yeah.
They had the picture before they came to the meeting, right?
100%, Your Honor.
Yeah.
Your Honor, children draw pictures of things. It doesn't mean, if every person who drew a picture meant that that was their intention going forward, I mean...
Oh, come on. He had a whole journal.
I don't want to call it a
what he
doodle
wanted
because
to
I don't want to undermine the significance of it. But to suggest that because he drew a picture and has never had a history of violence that his parents knew of, specifically his father, it wasn't foreseeable. It simply wasn't. I mean, when you look at Hopkins, he saw the same picture. But what did he say? What did he tell the officer? This kid's never been in trouble. I barely know him because he's never been in trouble. He comes to school, his attendance is solid, he's never got into fights, he's never been suspended. Why is that? Because he's never doing anything wrong. You're taking a kid who has no history of behavioral problems, of misconduct in school, and...
Well, there was a phone call the day before about... There was a phone call... They both were aware of the phone call the day before.
I don't know that there's...
About researching bullets.
Right. And, Your Honor... I don't dispute that that happened, but the fact that someone researches bullets, no one disputes that this was a hobby of his. It was a hobby that he enjoyed and that he did with his parents. And in some communities, that's a totally normal hobby for a 15-year-old child to have with his parents. And I think the testimony at trial very much confirms that in this community, that is nothing unusual, Your Honor. But when you look at the narrative that's put forth and how it shifts, James Crumbley did not have the ability to cross-examine these witnesses about why their testimony shifted, why the information that they gave shifted. And it would have been a reasonable argument and a reasonable attack on their credibility, Your Honor, to point to the proffer agreements for the reason in that shift. But again, Your Honor, even under Davey, the prejudice prong is whether or not the defendant's ability to prepare the case has been hampered, right? And that's exactly what you have here. That meeting and their alleged conduct and disinterest in that meeting was a huge part of the prosecution's case.
Okay, so you're talking about materiality. Do you want me to let the prosecution respond, or?
It's your courtroom, Your Honor. Whatever's easiest for Your Honor.
Well, I think it'd be best to issue it by issue. I guess I shouldn't presume that you're done talking about this part.
About the proffer?
Yeah,
I am.
Okay, well, I'm going to let them respond, and then I'll
100%.
let you reply.
Thank you.
Okay?
Thank you, Judge. I think the court, some of the court's questions, I think, correctly exemplified part of our argument, and that is the amount of evidence that was presented to the jury that is both uncontested and proved at trial that showed, irrespective of these witnesses, the guilt of the Crumbleys.
Okay, but you're jumping to the end. Mr. Keese, you agree that a prosecutor is under a duty to disclose any information that would materially affect the credibility of a witness.
Yes, Judge. Brady obligation,
If I had
of
a
course.
dollar for every time I said credibility is always at issue, I could retire right now,
Yes.
right? Credibility is always at issue, right? And so wasn't the defense deprived of a robust cross-examination?
No, Judge, and I do want to point out that the interview that counsel is referring to, that was turned over to defense. Defense counsel had that
Are you,
in the first...
Are you talking about the audio tape she sent me, or Exhibit 2 to your brief? Which interview?
The interview of Mr. Hopkins from November the 30th of 2021, along with the narrative statement summarizing that.
Sure.
So counsel had opportunities, if counsel saw it at trial, to try to cross-examine on any inconsistencies. I don't believe there to be any material inconsistencies, and I'll get to that, Judge. I do want to highlight just a few things. I want the court to recall that the evidence showed that it was approximately 1:10 p.m. on the afternoon of November the 30th, 2021, when the active shooter alert went out to parents of Oxford High School students. Those parents raced to the high school in hopes that their children were unharmed and alive. But James Crumbley didn't. He went home. He went home to look for the gun that he bought his son just 4 days before. He went home because he knew his son was the shooter. James Crumbley is the person who bought the murder weapon. He's the person who didn't lock it up, even though he was given the cable lock and an easy way to do so. James Crumbley knew his son had lost his only friend just the month prior. James Crumbley knew that his son's only hobby at this point was going to the gun range, and that his son had voiced signs of mental distress months prior. It was James Crumbley who wrote to his wife, "My God, WTF," when he was shown that math worksheet. This series of choices that I've just outlined led directly to the deaths of Hannah St. Juliana, Madison Baldwin, Tate Muir, and Justin Schilling. And those series of choices had absolutely nothing to do with Ejac or Hopkins. But not only that, I dispute that the crux of the testimony of Hopkins and Ejac was not uncontested, because it was uncontested. No dispute that Hopkins called the parents to the school. No dispute that math worksheet was sent to both of them. He provided a list of mental health resources to the defendants at that meeting. We know that because that's on video. He said he wanted them to get their son help that day if possible. He never testified, and he never told anybody that he had threatened to call the school resource officer or the police. It's uncontested the length of the meeting. We know that because it's on video. We know the shooter went back to class. We know that no discipline was handed out. We also know that neither Hopkins nor Ejac voiced that they thought at that time that the shooter was a threat to anyone else but himself. That uncontested evidence was used in part by the defendant to try to cross-examine those witnesses. This isn't testimony used to stretch or to impress the prosecution. That was just what happened. This is not evidence of somebody who was trying to curry favor with the prosecution, Judge. And that's important because ultimately, if the court has already made this decision on discovery violation, ultimately the decision is remedy. I don't think you should, and I would like to go through that discovery violation briefly, if I may. Okay. As much as I believe that our position is correct and the law is clear, I don't want to leave the court with the impression that there was an effort to hide evidence or gain an unfair advantage. I understand and appreciate the knee-jerk reaction that occurs when it's learned that a proffer agreement wasn't disclosed in discovery. I've done dozens of them. I've petitioned the court for immunity dozens of times. So I understand that knee-jerk reaction. When a co-defendant flips, they proffer, they're given a plea agreement, and they provide testimony, that always goes to the co-defendant. Always. The same as someone is given immunity to testify. And the court correctly identified this. We petitioned the court for immunity to compel testimony. That's what use immunity is, Judge. And whether or not there is some sort of other name for immunity out there, that is not what was included in the proffer agreements.
Well, I think what Ms. Sharon said is they got something.
They got the opportunity to tell us what happened in the first meeting and first meeting only, with a promise that we wouldn't use what they would say to us should they be charged later on.
Yeah, well, there's an incentive there, right?
Judge, to the extent that they had any incentive to tell us what they wanted to or tell the police, that would have existed irrespective of the proffer agreement or not. They were sued in, I think, 1 week after the shooting. Multiple lawsuits, they're sued personally. That was not a secret. The civil depositions occurred post-exam, pre-trial. Trial counsel had copies of their depositions. Sean Hopkins testified 4 times. Nick Ejak testified 3 times, each without protection.
Have they testified before the proffer in the civil case?
No, civil case was post-preliminary examination, pre-jury trial.
Where were the depositions in the civil case in relation to the proffer?
Post-proffer.
Post-proffer.
Yes, proffer is 2021.
Okay.
I don't know the date offhand of the civil depositions.
Okay.
I do know that it occurred because we obtained the transcript, as did trial counsel. The prosecution was not a party to that. Now, I say all of this because I appreciate advocacy for a defendant as well as that knee-jerk reaction. But it is one thing during the appellate process to argue the interpretation of a court rule and quite another to assign ill intent. And I think that's important for the court to know when reviewing remedy.
Okay, but you're not telling me that it was a boo-boo, right? It was intentional. That it was. There was a willful non-disclosure.
No, Judge.
You guys decided you didn't think you had to turn it over, right?
Thank you for bringing that question up, Judge. And I want to go back to the Nick Ejak statement because I think this is a perfect example of this. At the last hearing, the co-defendant's hearing, we talked about the recorded statement of Nick Ejak. That occurred in 2021, and when it was decided to have him testify for the prosecution in 2024, we should have gone back through and identified that as a statement under the court rule. That was a mistake and was made without malice. It's not being argued here today because there's nothing exculpatory about it.
Well, I did think it was interesting that I wasn't provided with it. That means no one really cares about it, right?
Correct, because there's nothing exculpatory about it.
Oh.
Now, in the same vein, the proffer letters in 2021 were put in the work category box. They were not revisited in 2024. The law supports, as much as I firmly believe, and that's why we briefed this is why I'm arguing this to the court, that the law supports my position that the reading of the court rule does not require that. It does not mean that these proffer agreements were shoved in the back corner of an office and decided to conceal evidence from the defendants. It wasn't turned over, Judge. That's a fact. But it would be an error to ascribe ill intent to that.
Well, it was intentional that they weren't provided. I mean, it was
right. But I don't want.
You guys didn't forget they existed for sure.
I don't want to paint the picture, Judge, that we had a roundtable discussion about this to talk about whether or not to disclose the proffer agreements or not, because they were very quickly identified not to be discoverable, Judge. Okay. We went through items. We went through statements of witnesses. Do we need to redact this? We went through body-worn camera. What portions do we redact? What portions are relative to the case and fit the court rule? That sort of analysis didn't occur with this evidence, Judge. And I don't want my advocacy here regarding the court rule and the interpretation of the court rule to be mistaken for an admission that we tried to hide anything from the defense. So that's the point I made, because that's very different. That's an important distinction, Judge. I want the court to know that from the prosecutor's intentions throughout this case, from deciding whom to charge with what crimes, discovery process, trial preparation, and trial itself, were just. And I want to highlight something that is, I believe, a perfect example. This court recalls how we came to have separate trials to begin with. Trying this case twice was a logistical nightmare for a number of reasons, really? Judge, as this court knows. Our witnesses had to testify twice on international TV. Most importantly, we had to put our victims through this twice, and they had already endured 2 long years of seemingly endless litigation at that point. But it happened because...
Torture for everyone.
It was, Judge. Mm-hmm. And the reason it occurred is because we listened to jail calls, we interviewed witnesses on Jennifer Crumbley's witness list, and we learned of Jennifer Crumbley's desire to present antagonistic defense. We reported that to counsel as well as Your Honor at a status conference, as I'm sure you recall. We did that to ensure the integrity of the proceedings as well as protect the rights of the defendant.
I think that was inevitable anyway.
Either way, Judge, we didn't have to... We learned of it on our own, Judge. Trial counsel did not ask for that. Whether or not the court was going to grant it or not, I can't say. I can just relay to the court what happened to make sure the record is clear. In addition, we created waivers to make sure the defendants knew the dangers of joint representation. We created waivers when the trial counsel split to make sure they knew about how to protect prior client safeguards. We made sure and we requested that independent counsels were appointed to interview these witnesses in the jail, these defendants in the jail, so they understood the dangers of proceeding. Every time a question was asked of the co-defendant during the trial that might elicit prejudicial information, we asked the jury to be removed from the courtroom, and the defendant herself was voir dire to understand that was knowingly happening. Way back in the preliminary examination, when trial counsel was in danger of conflating the evidence as to each defendant, it was the prosecution who stood up and made a point to notify the judge and trial counsel we have separate defendants, separate pieces of evidence. Judge, again, we do this to protect the rights of the accused, and it would be wrong to ascribe ill intent to any real or perceived discovery violation. But let me talk about the court rule. So 6.201B5 says upon request, the prosecution must provide each defendant with any plea agreement, grant of immunity, or other agreement for testimony in connection with the case. I do not agree with counsel's interpretation of the rule that for testimony does not apply to all three phases here, and I certainly do not agree with counsel that these proffer agreements were immunity agreements. I talked about this the last hearing, Judge. If the court has questions regarding that, I can certainly go through it again, but I'm sure the court recalls. I adopt those arguments here today. As much as counselor or the court cannot inject a word or phrase into a court rule, at the same time, we can't make an agreement something that it's not. We met with these witnesses to prepare them for trial multiple times. The proffer agreements never came up again. Their attorneys didn't even show up for those prep meetings most of the time. That is not a situation that we commonly think of as a proffer agreement that must be turned over. So that is an important distinction, Judge. Let's talk about prejudice now. We briefed that extensively. Judge, we also briefed extensively the whole last antecedent series modifier rule. If the court has additional questions on that, I'm happy to answer, but I think counsel, as well as the prosecution, briefed that extensively. Judge, even assuming that these proffer agreements would fall under the court rule, the defendant must show actual prejudice. And that's where we look at the same standard as Brady materiality. And that is why I started off with all of these series of choices that James Crumbley made, irrespective of those two witnesses. Evidence is material.
This is Chanel 495
Yes, Judge.
142, 2014 Michigan Supreme Court case.
Yes. And Judge, going back to, I described what happened with the proffer agreements and their non-disclosure. Counsel did make a point to say that I disclosed discovery 34 times and each time chose not to turn that over. That's not true. It was the first time, and it wasn't revisited. That's an important distinction. It's not splitting hairs, and again, it's something for this court to keep in mind when determining remedy. I'm sorry, I interrupted you regarding Chanel.
No, I just wanted to...
Right. I think that's a great case to review because of what happened in that case compared to what happened here, Judge. Sean Hopkins and Nick Ejak were not needed to identify the defendants. They weren't needed to, didn't have motive to put a case on somebody else. The evidence that convicted James Crumbley occurred wholly distinct from anything that Sean Hopkins or Nick Ejak were involved in.
Well, the prosecution certainly wanted them here, right? Even though it was only a 12-minute meeting, there'd be a small hole in the trial, right, if they weren't here?
Well, Judge, as a matter of trial strategy, we try to give the jury as much context as we can. It does not mean all of the 20 witnesses were essential to the case. Honestly, we could have convicted the defendant with just Detective Rogowski and Lieutenant or Undersheriff Willis's testimony, Judge, because the bulk of this evidence came through Facebook accounts, text messages, video, as well as the evidence that was sent to James and Jennifer Crumbley. We didn't even need these witnesses for a foundation for that math worksheet. The fact of the matter is, and we made a...
I agree with that.
Thank you, Judge. We made a point about talking about this in the opening, throughout the trial and closing. Hopkins and Ejak knew this much about the shooter and about the Crumbley household. That's nothing we ran from. The counsel just argued in support of her position that he didn't know about the shooter because he wasn't in trouble. That's true, and we never tried to argue anything to the contrary. He knew this much. James Crumbley knew this, and that's the point. That's the point. It takes a rare set of circumstances to convict a parent of involuntary manslaughter for the intentional acts of their son. That's why it doesn't happen very often. It takes causation, it takes gross negligence, and it takes foreseeability, Judge. And everything else that James Crumbley knew, that's what convicted him. There just weren't very many factual disputes in the trial. That's the crux of prejudice and materiality. I'm with the court.
What do you think about Taylor and Davey, though?
Davey is cited by Dickinson, Judge, in support. It's cited by Dickinson. And the crux of Taylor is that the objecting party should not be put in a better position. This would put James Crumbley in a better position. Dickinson's test of outcome determinative prejudice is the guide for this court, and that is why it is the same test for materiality, Judge. Evidence is material if it creates a reasonable probability of a different outcome. That's the standard. What is material is all of the evidence uncontested that James Crumbley knew about his son, all the evidence that was proved by a number of different witnesses, not named Hopkins and Ejak, proved by forensic download and cell phone, Towers GPS data that proved that James Crumbley was grossly negligent, that proved that he was both the proximate and factual cause of death, and that this was foreseeable to him. We did sort of get into the argument on the Fifth Amendment aspect of it, not Fifth Amendment, regarding the duty. Thank you. If the court would like me to.
Do you want me to let her respond to you, and then we'll talk about duty? I issued a ruling already on inconsistent theories and duty and unanimity, right? So.
Not in this case, Your Honor.
Wait, not with regard to this case, but there's plenty of overlap. So I know I'm just stressing that so that you hit the highlights, and I know there's some things in your brief that were not in the brief presented on behalf of Mrs. Crumbley, but yeah. So can she reply to you? Or?
It's whatever the court would like, Judge. And there's just one other thing that the counsel mentioned that I neglected to bring up earlier. Only four people in the world knew about these proffers. That's not true. I mean, Hopkins and Ejak both had their attorneys. We never asked for an NDA. We never told anybody to keep it quiet. I have interviewed gang member witnesses before where their safety would be in danger if things got out, if they didn't testify. That's not the case here, Judge. And I keep bringing this up, the difference of what we commonly refer to as proffer, just because I think I want the court to contextualize what actually happened. I just want the court to be aware of that. And the only aspect on duty I want to bring up is that essential part of duty is foreseeability, which was instructed to the jury. That was part of the jury instruction, so that's all on that part, Judge. Thank you.
You want to reply?
Thank you, Your Honor. A couple things. It's always difficult because I can never read my own handwriting. But when Mr. Key stands before Your Honor and says that these proffer agreements were identified as not discoverable, frankly, Your Honor, that's terrifying. It's terrifying to think about potentially how many other cases they haven't disclosed similar agreements. It's terrifying that a prosecution team with 83 years of experience doesn't know that they have to disclose this under Brady. My reaction is not a knee-jerk reaction. It's a reaction that is born out of the Constitution, out of defendant's right to due process and to present a defense and to cross-examine the witnesses against him. So if our Constitution wants to be called a knee-jerk reaction, then that's fine. But my reaction, and I think the reaction of a lot of people, Your Honor, stems from constitutional guarantees that a criminal defendant has. And I'll knee-jerk react to that all day, Your Honor. Your Honor, he made a comment and sort of went through this litany of events that speak to the virtue of the prosecutor's office, that because they did the right thing in one instance, it means that there was no bad intent here. Your Honor, I'll tell you what the difference is. The difference is those instances that Mark Keese talked about were instances that were on the record in open court, not in a closed room at the prosecutor's office where they could shove a proffer agreement into a drawer and not revisit it for 2 years before this case moves to trial.
No, I don't think he's talking about instances that were on the record. We had a combined pre-trial conference in the jury room, and that's when the prosecutor raised that there were jail calls from Mrs. Crumbley basically indicating she was going to flip on her husband. So,
Right, but that's known to the defendant.
It
It is known to a defendant. Jennifer Crumbley knows that she's planning on flipping.
Yeah, Mr. Crumbley didn't know that.
I understand that, but she knows, her attorney knows, it's not something that's clandestine. It's not something that the parties aren't aware of.
Mr. Crumbley and his attorney didn't know.
I understand that, but Your Honor, if one defendant knows about it and that defense counsel knows about it, quite frankly, I'm not sure why the prosecutor's patting itself on the back, because defense counsel would have had an obligation to disclose it anyway. So it's not as if they were, well, I'll just leave it at that, Your Honor. Again, I want to stress the distinction between discovery violation and Brady violation. The tests are different. The tests for materiality are different. The discovery violation, Your Honor, is the stronger argument for Mr. Crumbley. I believe he wins under both, but with the discovery violation, that outcome determinative language is not required to impose the sanction. And I 100% agree with Mr. Keast that the case law says, right, that the sanction or the remedy should not be a windfall to the defendant. 100%. The defendant should not be in a better position after the remedy. But to argue that Mr. Crumbley would be in a better position, I mean, that's illogical. That's illogical. If you grant a new trial, you are putting him in the position that he should have been in when his trial started. He should have known about the proffer agreements. His attorney should have been able to cross-examine Hopkins and EJAC about their bias and motive stemming from the proffer agreements. So I really struggle to understand how he would be in a better position. He would have his day in court that he should have had when he first went to trial.
I don't know. I guess one of the problems with that in Mr. Crumbley's case is, regardless of whether Mr. EJAC or Mr. Hopkins testified or not, I mean, Mr. Hopkins wasn't going to say, it was me, I was the straw man who purchased that gun and gave it to the shooter.
Sure.
I mean, you can't, right?
And I was just going to reply to that, Your Honor. So the prosecution keeps saying that there's this tremendous amount of evidence that's uncontested and uncontradicted. And I really think there has to be a qualified statement to that and context to that statement, because it was uncontested because EC didn't testify. It was uncontested because his medical records couldn't come in at trial. Because if there's one thing my brief makes clear with citations to the CFP report, is that this child told the Center for Forensic Psychiatry that he never told his parents he needed help, specifically his father. That when he was feeling suicidal, he did not tell his parents. He put on a happy mask, a happy face. So when you look to the CFP, there is plenty to contradict the prosecution's theory. It just wasn't allowed in at James's trial.
Okay, well, there's good reason for that, right? It's hard.
I would respectfully disagree.
Well, I guess that would be for the Court of Appeals of the Supreme Court.
Agreed.
I guess I would say to you that we fought long and hard, researched. Everybody involved in the trial spent a lot of time. And there is no allowance at all for those records not to be privileged. Those records are privileged. I don't know what to say. Can I say that some of it is unfair? Maybe. But I think you're supposed to get a tape next week of the hearing we had under seal. But to be honest with you, I think you're going to figure out that when you get that sealed record, it's anticlimactic.
Your Honor, so the sealed record, of course, is from Jennifer's trial, not
right.
There was no separate
right,
sealed
but
record.
It's a reference. It talks about references to mental crisis by the shooter.
Your Honor,
we're getting in the weeds, right?
Yes, Your Honor.
I guess I understand your concern about not having the records from the Center for Forensic Psychiatry, but both sides, all three sides in this matter, researched, looked at the law. So did I, for many, many hours and many evenings and many times when I should have been sleeping. And there is a feeling of unfairness potentially about that, but there's no question in my mind that those records are privileged, and the privilege is held only by the shooter. So I don't know that there's a way around that.
and I know that this isn't an issue before the court, but certainly there is authority that privileges must bend to a defendant's right to present a defense, his constitutional right to present a defense.
I've seen those cases, yeah.
And because those records didn't come in, Your Honor, the jury is presented with text messages, right? Not even direct testimony from EC that he allegedly told his parents that he was suffering mentally, and you have a complete 180 when he's interviewed at the CFP. A complete 180.
I'm not positive that the prosecutor wouldn't also like those records to come in. That's right.
Oh, Your Honor, the records are relevant. First of all, the records in their entirety are not relevant, right? Because there's a lot in that report that deals with information that James Crumbley knew nothing about. And that's never been contested, right? Certain disturbing actions by EC, right? There's no evidence that James Crumbley ever knew about those activities. So that would be completely irrelevant in a trial against him, and it would be highly prejudicial. But what is incredibly relevant, okay, and what Prejudice's defense was that the jurors were never told that EC repeatedly told the CFP that he did not tell his parents he was struggling. He did not tell them he was suicidal. And he specifically explained that he didn't do it because he didn't want his parents to think he was not normal, or he didn't want to make them worry. So, Your Honor, that is incredibly exculpatory for Mr. Crumbley. So what I don't like is this suggestion that there is uncontested evidence. It's uncontested because the evidence wasn't allowed in, not because it doesn't exist, Your Honor.
We're talking about the fact that he bought his 15-year-old son a gun, left it laying around unsecured, and was presented with that picture in advance of coming to the school.
So, Your Honor, and now we're kind of getting into the duty, so can I kind of transition?
Sure. Well, I know you responded to Mr. Keese, but yeah, so you want to talk, I'm going to let you make a record about duty, for sure.
Okay.
Okay.
Your Honor, so first of all, I would say that additionally, EC, reported that the gun was hidden from him. He went into his parents' room knowing that they were sleeping and removed that gun at a time when he knew that they would be sleeping and that they had hidden it from him.
They did a bad job.
Not all parenting is perfect, Your Honor. They kept it from him, and they were not legally obligated to lock it at that time. Your Honor, as it relates to the duty issue, so it's undisputed. I don't think the prosecution contests this, that there was no evidence at trial that James Crumbley knew of any prior intentional tortious acts by EC. There is no evidence of that. Without this knowledge, Your Honor, he cannot have a duty. There is no legal duty, and there is no ambiguity in the case law. In its brief, the prosecution cites from the Muma case, which is a case that I cite, and they cite the following language. Since the law, as stated above, stresses foreseeability as a prerequisite to a finding of actionable negligence in cases of lack of parental supervision, and we find no such foreseeability here, we hereby affirm the lower court's judgment. That's the quote in the prosecution's brief. But if the court looks to just the preceding paragraph, right, you would see that also in the Muma court, it talks about the child in the Muma case, right? He takes his parents' car and he gets into an accident and inflicts injuries. And the court says that the child did drive the car the day before the accident, but this was after his parents had left for the weekend. Therefore, the defendant parents could not have anticipated or foreseen that their son would take the car while they were away, since he had never done so before. Mm-hmm. Foreseeability, Your Honor, is born out of a parent's prior knowledge of prior tortious intentional acts. That is what makes that child's acts foreseeable and what gives rise to the legal duty. There is no evidence of that in this case. What also strikes me, Your Honor, is that the prosecution asserts in its brief that the cases on which I rely do not include this requirement. And frankly, it's as if they didn't read any of the cases cited in the brief. Your Honor mentioned I took it as a comment on the length of the brief, which is fine. I mean, it was long. But it's long because 51, that's even longer than the Court of Appeals accepts at this point. But But the cases, Your Honor, that are cited, I don't just give the court the name of a case. I explain the facts, the holding, why it applies. And what's amazing is that they make a blanket assertion that none of those cases stand for the proposition that I use them for, and give you no analysis of how those cases are wrong or how they don't say what I say they say by way of copious direct quotes from the case. So if you remember, they criticized defense counsel in their brief, not me, trial counsel, about abandoning an issue, right? Because you can't just make a claim and then completely fail to develop it. That's exactly what they do when it comes to this duty argument, Your Honor. They just want to say to Your Honor, hey, Judge Matthews, what she says the cases say, they don't really say that. Okay, now let's move on. Let's not engage in any meaningful analysis to persuade Your Honor of that point. The case law is the case law. Prior knowledge by a parent is what gives rise to the legal duty. There is no evidence of that here.
Don't you think that the Court of Appeals sort of touched on this?
I do think that they did. And frankly, I don't.
They talk about
I'm
this
trying
being
to
an
be
extremely unique set of circumstances.
Your Honor, different.
You don't want to call out the Court of Appeals on the record?
Oh, no, that's fine. I think my reputation there is good enough. But different lawyers will raise issues in different ways. Sometimes lawyering from one lawyer may be more persuasive than the next. I wasn't there. I didn't read the briefs. You know, that's not really necessary for my representation here. But what I can say is, where there is no prior knowledge, there cannot be a duty. And if you look, a case that came out after Crumbley, it's People versus Aish, it's AIYASH, came out maybe even the last 8 to 12 months. It's that horrible case in Detroit where the clerk locked the people in the store and they got into a fight, and then one guy who's locked in there shoots and injures and I think kills one of the other people in the store. Your Honor, you know, one of the reasons why the clerk there wasn't held responsible was because he didn't know this person. He didn't know any prior instances of violence. And that is the same here. That is absolutely the same here. The prosecution has never argued that James knew EC was violent, that EC was ever violent before. And we know from Hopkins, he was not a kid that got into trouble. He didn't get into fights at school. He didn't get into fights in the neighborhood. Nothing. There is no evidence.
Why did he have to know that there was some prior instances of violence?
Because that's what the case law requires.
Didn't he just have to know things about him, like all the things that were happening in his life, including the friend, the fact that there was an unsecured gun at his house. He had access to his Instagram.
Okay. Your Honor, just first of all, just because someone has access to Instagram doesn't mean they're constantly trolling it. But to answer your question, Your Honor, if you followed Your Honor's...
This kid had silhouettes all over his room, right?
It was a hobby that he did with his mother. That's not... Okay, shooting a gun is not in itself violent. If you're going to the range, I mean, that's essentially saying that anyone who goes to a gun range as a hobby or to practice is violent.
No, of course not. But he knew that his son was... And then there was the phone call the day before about him looking up... He was so upset. He had to be at school. Well, he was at school looking at bullets and things like that. Like it's not just one thing.
But the law requires. And I'm sorry, I didn't mean to interrupt.
Go ahead.
But the law requires knowledge of prior intentional tortious acts. Otherwise, there cannot be foreseeability. That's what the case law. I mean, Your Honor, you have cases that I cited where the parents had some knowledge that the children were engaging in sort of somewhat nefarious conduct, but because there hadn't been explicit acts of violence, then the parents don't know about the propensity of that child. You have a child here who engages in a hobby with his parents as a way of spending time together. That is not an act of violence, okay? And to suggest
I
that
agree with you.
to suggest that just because he may have been struggling and feeling sad, which is what Hopkins described him as, right? He just seemed sad. To suggest that somehow gives foreseeability of someone committing a mass shooting, okay? In today's climate, 80% of us are probably sad the majority of the time. That doesn't mean we're going to go commit a mass shooting, and it certainly doesn't make it foreseeable. The standard is prior knowledge of prior intentional tortious acts. Without that, Your Honor, there is no legal duty for the parent to act. Your Honor, that is my argument as to the duty part.
Okay.
That concludes
Well,
the duty portion of the program. Does Your Honor want to give Mr. Keys an opportunity? I don't know. Do you want to?
Would you like to respond
Sure.
to the argument?
Just briefly. This has been before this court before, so I'm not going to belabor the point. I believe the court is correct. The Court of Appeals did touch upon this, as well as the court.
I should say that I'm definitely interested in and required just to consider each defendant individually.
Of course,
separately.
of course. Thank you for making that record, Judge, and that's absolutely true. I bring that up only because the issues are so similar, and I believe the court can draw from that. It is, again, a unique set of circumstances, and the Court of Appeals made this point, as did we in the Court of Appeals, and to the jury. A unique set of circumstances where a parent could be held responsible for the acts of a teenage son. Foreseeability is key. I agree. Foreseeability is an essential part of this, Judge, and that was argued to the jury. That's a jury question. Those are the aspects that were put forth to the jury, and the jury made that determination. There are multiple ways. So Alvin states clearly that the law in Michigan is that a parent is under a duty to exercise reasonable care so as to control his minor children as to prevent them from intentionally harming others or from so conducting themselves to create an unreasonable risk of bodily harm if that parent knows that he or she has the ability to control his children, and two, knows of the necessity and opportunity for exercising such control. Of course, should James Crumbley have been made aware that his son was shooting at people in the past or engaging in some other sort of violent, tortious acts, that would be evidence of foreseeability, but it's not required. It's just simply not required. So regarding the duty aspect of counsel's argument, I'm asking the court just to refer back to the first motion to quash that we had. That was what was appealed to the Court of Appeals, in the Court of Appeals opinion. I believe it's clear in that aspect. I do want to go back and make one quick point. When counsel talked about the forensic report, as this court sort of alluded to, and counsel's a bit of a disadvantage because she wasn't here for that argument and it's still sealed, but the court did find...
I think you're going to get it this week.
That's fine, Judge. Yeah. And the point I wanted to make is just so the record is clear that the court did find that there was nothing exculpatory in that. In the court,
was one section, though. I should point out that was one portion of the Forensic Center report that was specifically requested, and we had the closed hearing.
That's correct, Judge. That's correct. And also, Judge, there's no criticism of trial counsel in not pursuing this issue. She removed the shooter from her witness list, probably for good reason, because it doesn't stop with just questions defense counsel asks. We have a whole lot of questions they ask, too. And there are a lot of information.
Are we going somewhere else now?
No, I was just responding to counsel's argument regarding the forensic report.
Yeah.
Yes.
Okay. Yeah.
Thank you, Judge.
All right.
Your Honor, I'm not going to address the duty issue anymore. I think it's been well covered. The last issue I intended to address was the Fifth Amendment issue. I do just want to just briefly say a little bit ago, Your Honor mentioned that you had already previously ruled in Jennifer Crumbley's case on some of the legal claims that I think on their face or on the surface kind of overlap. But I do just want to stress to the court that as it relates to the inconsistent theories, there is no overlap between Mr. and Mrs. Crumbley's arguments. They are extremely distinct. They rely on different law. Well, the law is similar.
Well, you told me this in a pretrial, and that is specifically why I did not rule on everything with regard to Mrs. Crumbley, because you did persuade me that it wouldn't be fair to not read your brief and listen to your argument. So.
Thank you, Your Honor. So I just wanted to point out, especially when it comes to that issue, the arguments are very much distinct. Your Honor, as it relates to the Fifth Amendment, I don't have a ton to say here. I do just want to point out that the prosecution's argument in its brief really doesn't make sense from a chronological standpoint, because they criticize trial counsel for not filing a motion back in 21 or 22 about EC testifying.
No, I think what happened is that we were all here, and Miss Smith said, in Mrs. Crumbley's case, this is when they were together, Mr. and Mrs.
Yes, Your Honor.
So she said something to the effect of, "I'm going to need the shooter as a witness," and knee jerk, I said, "You can't take a fifth in front of the jury." So
of course,
you got to send up a flare if you think that's going to happen, because he can't take the fifth in front of the jury. So I pointed that out, and I encouraged a motion on that issue. And at that time, both of the defendants were together. So Miss Smith was here and Miss Lehman was here. So I think that's what the prosecutor is alluding to. That's back when they were together, and I was sort of surprised to hear that, because that would be a whole thing, right?
Surprised to hear what, Your Honor?
That she said that Miss Smith said she wanted to call the shooter, and then later made it sound like I was required to compel the shooter to testify, right? So that.
Okay, so I
said, bring. This needs to be, if you think that you can bring the shooter in and I can compel the shooter to testify, and this was directed to Miss Smith, you better file a motion, because that is not how I read the law. And so the prosecutor's point is that Miss Lehman was there. So anything brought in this case caused a little tidal wave, and everybody to start scurrying around and researching and setting dates for pretrials and hearings and all that. So everybody in the case knew if there's an issue, you need to tell us what it is.
So Your Honor, to respond to that, my point is that in 21 or 20, so that hearing happens, I believe it's June 27th of 22. Mr. Keese, if I'm wrong, feel free to. Okay. Is that at that point in time, there had been no invocation. No one on behalf of EC, and EC himself, had not invoked his Fifth Amendment right against self-incrimination. What had happened at those
Correct.
time periods, thank you.
At that moment.
Correct. So there was nothing ripe to bring before Your Honor in terms of filing a motion to compel testimony, because he hadn't invoked. The very first invocation happens, I think it's 1 day prior to Jennifer Crumbley's case, which is January of 2024. So
I think there was a feeling of shock when she said that, because I think everyone at that time truly believed that calling the shooter as a witness would be tantamount to dropping a bomb in the middle of the courtroom.
Well, Your Honor, and okay, I don't disagree, because Your Honor is entirely correct that you can't put a witness on the stand knowing that they're going to invoke. But no one knew whether or not he would invoke. That's number one, because he hadn't invoked. And then once he does invoke, respectfully, Your Honor, that imposes certain obligations on Your Honor. The case law is clear that when an attorney or a defendant makes a blanket invocation of the right against self-incrimination, there must be inquiry, right? The court, respectfully, is not free to simply accept that blanket assertion. So when does that assertion happen? Late January 2024, like a day before. Well, it kind of starts the day before Jennifer's trial. Then it's solidified, I believe, the first day of trial.
Well, the state court defender's office sent a letter and then sent an email.
Right, but the letter respectfully wasn't a valid invocation, because in that letter she concedes that she had not met EC yet.
But the next day she...
Correct, 100%, Your Honor. But once that happens, right, what had to happen under the case law is that EC had to be brought here for a hearing outside of the jury. 100% nothing could have happened in front of the jury. But the court is required to make a finding that the invocation is valid and that he understands it. Your Honor, given the facts in this case, I think it is, I don't want to say highly likely, but a distinct possibility that EC would have testified. in his parents' trial.
The prosecution would have loved that.
I don't know that, because then all of his statements to the CFP, Your Honor, about never telling his parents that he was struggling that is the center of their case. These text messages to friend B that he is having hallucinations, which, by the way, the prosecutor's own expert says he never had, okay? I mean, that goes to the inconsistent theory.
She questioned.
She said, Your Honor, very clearly that people don't share hallucinations. And every time he talked about hallucinating with the doctor, the expert at the CFP, he talked about sharing that his friends saw the same hallucination he was seeing, which led Dr. Anaker to give the opinion that he was not experiencing hallucinations.
Okay, so you're saying I didn't correctly handle the Fifth Amendment issue because I didn't bring the shooter here in his bulletproof vest and put him on the stand and ask him if he was going to take the Fifth. But, so you say the Fifth Amendment was not invoked, but I think it was invoked over and over again by his counsel.
No, it was invoked. I don't dispute that it was invoked. I dispute that in 21 or 22 that it was invoked, which should have led counsel to file some type of motion. It wouldn't have been ripe at that point because nothing had been invoked, and I think Your Honor agrees with that. But once he invokes, Your Honor is required under the case law to make a finding if the invocation is valid and to make sure that he understands the invocation. And that didn't happen here. And yes, I do argue that he did not have a valid assertion under the Fifth Amendment because counsel could have asked questions, Your Honor, narrowly tailored his questions, her questions, excuse me.
What question? What question would not be covered by the Miller hearing, the fact that the Miller hearing and the resulting sentence was being appealed? I think everyone in the courtroom at that time was surprised when Mrs. Smith said she was interested in calling the shooter. I can't imagine a way to call the shooter.
Because if the questions asked of EC are confined to information that is already known by the prosecution and by the sentencing judge, how can there be additional incrimination?
I don't know. I can't imagine a question he could have been asked.
Your Honor, I go through a list of 17 of them in the brief.
I know I saw them. Did you go on a camping trip? I don't think that he could have answered any of those questions. A lot of those questions are from a Miller hearing because his background...
No. That information is lifted from the CFP report. That's why I specifically tailored it to that.
That's separate, though. That's separate. Just because he answered questions in a forensic center interview doesn't mean he can be compelled to testify under oath
Your Honor,
those questions when they would also be the subject of a Miller hearing, right?
They were already the subject of a Miller hearing. They
Which is
were
still on appeal
already 100%. Those facts were already known to Judge Rowe. The CFP report was made an exhibit at the Miller hearing, which means the prosecution and Judge Rowe were already made aware of all those 17 facts that I list in the brief that are all helpful to James Crumbley because he is portrayed as some disinterested, negligent father, and the fact is that EC statements at the CFP do not support that. They don't support that.
I know that's your position, but try as I might, I couldn't do anything about that.
I understand that, Your Honor, but it was required that Your Honor make that inquiry. Counsel does not have to ask for it.
I didn't bring the shooter in and ask him. I didn't.
And, Your Honor, the only way to remedy that is with an evidentiary hearing.
Okay, so you want me to bring the shooter in and ask him?
I want the court to make sure that it was a valid invocation and that it was appropriate. That's how you correct the mistake.
I guess I would have to say that I'm satisfied that he invoked his Fifth Amendment rights.
That's not the question.
Okay.
The question is whether or not the blanket assertion is appropriate. Respectfully.
I'm feeling confident, respectfully.
Your Honor, that's all I have to say on the Fifth Amendment issue. I did just have one other, and I don't know if Mr. Keese wants to respond. I did have one other sort of point that I wanted to make to the court that kind of culminates everything.
Okay.
But I can certainly wait, or Your Honor can just tell me to sit
I'll let him
down.
respond. And
Thank you, Judge.
one or both of you might not be happy with my ruling, but you won't say that. Let you say everything you wanted to say.
Thank you, Judge. I'll be brief because I believe the court recalls the June 27, 22 hearing, and I do want to point out that we do assert that Ms. Lehman abandoned the issue, but that's not critique or criticism. That's just appropriate to point out for the appellate posture of the case, Judge. And she abandoned it likely for good reason, as the court has already indicated and read that friends. Now, the fact of the matter is that the shooter's own expert at the Miller hearing called him a feral child. If that information were all to come out, Judge, like you said, it'd be tantamount to dropping a bomb in the middle of the courtroom. Judge, the fact of the matter is that the information that would come from the shooter, every question would be an issue for him. There's an opinion yesterday from the Michigan Supreme Court regarding juvenile lifers, Judge. This is an ongoing issue. We're in the middle of the appeals right now. He asked for a new trial or to withdraw his plea already. That was denied. That's on the appeal currently, Judge. Anything that would have been asked by either party would be an issue for him in the Miller hearing. I think the court is understanding that. So if the court has any other questions, I'd be happy to answer. But I do just want to refer for the record back to the court's soon-to-be unsealed record regarding the forensic report and its non-exculpatory nature, and the fact that, again, we never stood up and said privilege. We just said, as the court correctly pointed out, he does have a privilege, and all parties research that issue. Thank you.
Well, I did a lot of research about that because, obviously things that he said, the shooter said, would be of interest and relevant to both Mr. and Mrs. in their
Get your votes in before she
in
decides.
their trial. But there's no support for the release of it. I looked for it because there's just no support for it. It's the privileges belongs to the shooter and no one else. So, what else did you want to say?
I just wanted to kind of close. I do want to address one statement made
Go
by
ahead.
Mr. Keith.
I'm going to let you both
Wrap
say
it
whatever you
up,
want.
lady.
Thank you, Your Honor.
Wrap
You've been
it up.
extremely patient this morning. Mr. Keith mentions that that EC's own expert referred to him as a feral child. The prosecution's own expert said that EC was not mentally ill, that he was hopeful at the times preceding the shooting, that he was engaged in hobbies that he found enjoyable. So to the extent that you want to start putting out there what different experts said, it's the prosecution's expert who portrayed EC at his Miller hearing as hopeful and engaged and spending time with his parents and generally had a very good childhood without negligence and abuse. Those are, Your Honor, direct quotes. They are in the brief, and I've attached her testimony from the Miller hearing. So I am not playing fast and loose with the facts, Your Honor. Your Honor, I wanted to just sum up.
Sum it up.
Every time, Your Honor, that I've seen this topic of the prosecution's misconduct is discussed, whether it was when Jennifer Crumbley's motion for new trial was being arguing, whether it's in the press, the prosecution pivots. It pivots from the attention on its misconduct to the absolutely horrific murders that happened in this case, rather than focusing or even acknowledging their own misconduct. And Your Honor, it is, in my opinion, a very blatant attempt to distract the court and the public from how they failed to give James Crumbley a fair trial.
Oh, Lord.
How their misconduct robbed him of meaningful cross-examination
Denied.
and a chance to expose to the jury the biases of Hopkins and Ejac. This case, Your Honor, is gut-wrenching. It is heartbreaking, and it is traumatic for an entire community. But our rules and the court's obligation to ensure due process and a fair trial and full and fair cross-examination cannot bend to emotion, Your Honor. If it does, then our justice system has no integrity, and the rules mean nothing, and the Constitution means nothing. The parties must adhere to the rules, and you must enforce them equally to sympathetic defendants and to defendants who garner the most visceral of reactions, Your Honor. In this room, the law must reign supreme regardless of pain and trauma. And I can just see the headlines now, Your Honor. Callous defense counsel doesn't care about the pain of the families in Oxford. And that is not true. Your Honor, and it's funny, it's ironic because Mr. Keese just mentioned, the movement in juvenile lifer cases. When Miller was decided in 2012 and made retroactive in 2016, our courts repeatedly acknowledged how painful this change in the law was going to be for families, right? Families of victims who for decades had maybe reached a point that they could put this pain and trauma behind them, but we still changed the law. The United States Supreme Court required that mandatory life without parole be reversed, and that all these defendants come for resentencing, despite the pain that they acknowledge it would cause. In civil cases, Your Honor, sanctions are imposed to punish and deter, and all you're dealing with is money. This is a criminal case. This is a man's liberty. It is his freedom. It is his ability to live outside the prison walls. If Your Honor does not grant a new trial, you send a message to Karen McDonald and to her office that you will, and that the courts will, tolerate this type of misconduct, this type of constitutional violation.
Oh, come on.
And perhaps even more troubling, you send a message to prosecutors throughout this state that failing to disclose Brady material, information that is critical to a defendant's meaningful right to cross-examination, will not be sanctioned, Your Honor. Mr. Crumbley is entitled to a discovery remedy. The only remedy that can make him whole is a new trial, Your Honor. Thank you.
Oh,
Thank
she's
you.
done.
Anything, Mr. Keese?
Just briefly, Judge. Judge, throughout today's argument, I feel that my responses have been measured, and I've said over and over again that it is one thing to argue the law, it is quite another to throw around unfounded allegations.
Muggs.
And I sincerely take issue with the fact or the allegation that we prosecute for headlines. We prosecute for victims, Judge, for victims. That's why we're here and that's why we do this job. James Crumbley was convicted because of the choices that he made, the choices that led directly to the deaths of Hannah, of Madison, of Tate, and in Justin. It was James Crumbley's gross negligence. It was James Crumbley's causation in his foreseeability that was the reason for his conviction, Judge. The evidence in this case was overwhelming. I simply ask that this court review the law, follow the law, Judge. Our brief is detailed. Our argument, I believe, is clear. Thank you.
Thank you. I don't think you can expect something from me in less than a month, probably. I'll do my best, but I've been being very careful, and sometimes I think some of my other 550 cases have taken a back seat to these two cases the last 3.5 years. So I will do my best to get back to you as soon as possible. All right?
Thank you, Your Honor.
Thank you.
Thank you, Judge.
All right, so she's going to take a month. She's got a month to decide. You guys said 22% said yes, she'll give him one. 78% of you said no. Let's end the poll. I don't think she's going to, but a month, yeah. And welcome back, Mr. Bob. Good to see you. Ooh, biscuits and gravy. Well, I guess we wait for Judge Matthews for the next month. Another thing to wait on. He's asking for a new trial, Lee Michelle. This is the father of the Oxford school shooter in Michigan. Let's see. Let's look up Ethan really quick on Otis. Otis. That's the Michigan offender tracking system. Let's look up Ethan just for shits and giggles. Crumbley, Ethan. I don't know if he's got it. No, he's still got the same picture. Image date 12/12/2023. So they haven't updated his photo in a while. Him and his stupid wife. Hey, Michelle, you're in Michigan. A lot of Michiganders in here today. She's going to take a few days to write a letter filled with scathing language. Good to see you, young black economist. He's 6'1" and 204 pounds. He's a big kid, man. Look at all these charges. Crazy. But anyways, look up James and Jennifer. You want to see them? Okay. Let's look them up really quick. Jennifer is in the Huron Valley Complex Women's Prison. Her maximum discharge date is 12/2 of 2036. She's got the same mug too. 5'9", 170 pounds. Oh, this image was taken 4/11. Oh, wow. A year ago on the day. Look at that. A year ago on the day. Her earliest release date is 12/2/2031. Jennifer Lynn Sawden. That's her maiden name. Now let's look up James. That's Jen. Mm-hmm. All right, here's James. He's in Bellamy Creek Correctional Facility. Here's James. 6'2", 180 pounds. This was taken on 4/12/24. So a year ago. It's a crazy case, guys. There's a lot of dynamics that made it his earliest. Wait, look, he's got a tattoo, Casey, in Chinese letters on his arm. It must have been a girlfriend back in the day. His earliest release date is 12/2/2031. Involuntary manslaughter are the charges. Oh, I know, right? He's going to change a lot in the next couple years. Tempest, you don't think he does? I don't think he does either. I think they all try, though. All right, guys. Well, thanks for tuning in to this hearing this morning. You guys are going to be transported over to my friend Granny's Watching. If you'd like to watch her, she is live right now. She's one of my friends here on YouTube. So we're going to roll out the credits in our Patreon outro, and you will be transported over there if you'd like to let Granny's Watching know that Jay for Justice sent you. So let's yeet over to Granny's Watching. She is still live. Thank you for joining. I'll see you guys in the next one. We're going to be going over Coburger, so be looking for that. I'll see you guys in the next one. Thanks for your support. Bye. Thank you so much for watching. If you enjoyed this live stream or video, make sure to give it a thumbs up and hit that subscribe button so you don't miss out on my latest content. Want to take it a step further?
Bring it all in.
And join our community clickers by becoming a Patreon or a YouTube member. You'll get exclusive access to our Discord server, special channel perks, and much more. Until then, I'll see you in the next one.
Click. It's real easy, man.